lay out all of our case in the mounds of paper that the federal court requires.
And we had about 11 consecutive motions in court that we won. So we were riding a very nice wave of momentum as the case approached the trial.
So the first day we walk up and there's press outside the courtroom, and we walk inside the courtroom and there's tons of people. And then Dan gave his opening statement and it went really, really well. And I think everybody started to kind of settle into it after that.
The point of all the evidence we put on was to show that Don't Ask, Don't Tell didn't further any important government interest. And we did that by showing evidence about foreign militaries, how Don't Ask, Don't Tell was applied more often in times of peace than in times of war, evidence about how it disproportionately impacted women, evidence about how it created personnel shortages in areas where we needed more people, and how it actually overall weakened our military.
My best friend Jared, we served all throughout the military together. We met right away when I got to language school. After we'd been friends for several months, I found out that he was gay. I realized that this wasn't a problem. This didn't affect our friendship. It did not affect trust. It did not affect his ability to be an absolutely outstanding soldier.
Mr. Laverty was a fascinating witness because he thought it would be easier for him to hide his sexual orientation if he was in a high-intensity environment like a combat unit. He found the opposite to be true.
We also had evidence that the government knowingly deployed homosexuals abroad and only then tried to discharge them after they returned from their foreign service.
On 9/11, knowing that we could possibly be going to war, my captain could have easily left me on the pier. He could have said, hey, we're going to war. Gays are a detriment to good order and discipline. You can't go. He could have easily done that. It was his ship. He didn't have to take me. Instead, he put me in charge of getting the ship underway.
Our president has said that Don't Ask, Don't Tell, quote, weakens our national security. And we were able to argue that these statements were evidence, powerful evidence, against the constitutionality of Don't Ask, Don't Tell.
I've seen a lot of witnesses on the stand over the years, and our witnesses were terrific.
After countless months and phone calls and emails, they were actually testifying, and they were facing their fear of Don't Ask, Don't Tell, and they were doing their best to see that the law was deemed unconstitutional.
The Justice Department, I think, is the largest law firm in the world and could throw whatever resources they want at this case. And they mounted a solid defense.
Testifying against the U.S. government on this issue was exciting because, I just knew that we were on the side of right in this. We were on the right side of history. The U.S. government was on the wrong side of history. And, it made me very proud to be up there.
I was trying in a 90-minute closing argument to capture all the evidence that we had put on in the trial, but also to make it a powerful emotional argument that might help persuade the court to rule in our favor.
You could just hear a pin drop. It was so beautifully crafted and so powerful, and he really walked back through the entire trial in his closing argument.
Good evening from New York, a landmark in American civil rights tonight. The U.S. government, as of this afternoon, prohibited from discriminating against gay soldiers in the U.S. military.
Just to Fox News, and breaking news now on Fox News Channel Dateline, Riverside, California. Don't Ask, Don't Tell for the moment is out the window.
A permanent injunction against the policy was today issued by a California federal judge.
We had been waiting several weeks for the ruling, but obviously when it did come, we were very excited to have learned that we had won and that our challenge to the constitutionality of Don't Ask, Don't Tell had succeeded. We were also very impressed by how thorough and detailed the judge's ruling was. In her 85-page ruling, she explained all the reasons why she found Don't Ask, Don't Tell to be unconstitutional.
I think one of the most memorable moments was getting the ruling, getting the opportunity to call the witnesses and say, we won, we did it.
I think White and Case is to be admired for taking this case on and to sticking with it for the long period of time that it took it finally to come to trial.
I've been practicing for 23 years, and I can count literally on one hand the number of cases that I've personally handled that have had any kind of expansive impact, much less social impact. A lawyer has, I think, few opportunities in one's career to actually touch a case of national significance. And this is that case.
It's just about equal treatment of people. And I think that's a fundamental precept that needs to be advanced. And I think it's wonderful that White and Case was able to do that for gay and lesbian individuals.
This win was a win not only for the firm, and it wasn't just a win for log cabin Republicans. This was a win on a civil rights scale.
Taking on big pro bono matters like this is really part of the fabric of White and Case. It's who we are, it's what we do, it's what the firm has always done.
This morning, I am proud to sign a law that will bring an end to Don't Ask, Don't Tell.
I hope you like that. Let me tell you a little bit about some of the people you saw in the video. The first former service member you saw was Mike Walmy. Mike was a major in the Air Force. He'd been in the Air Force for 20 years. He'd been an officer for 13 years. He had several deployments to combat zones along the way. He received many medals and decorations along the way too. And so Mike is in the process of transferring from his third foreign deployment to the Middle East back to Germany, which is his home base. Somebody working with him turns on his computer, opens up his email. He has a Microsoft Outlook email program, like many people do. It had a file folder labeled Friends. The person who opened his computer looked in that file folder called Friends, in which there were 500 emails. Most of them were to and from his mother, because mothers worry about their sons when they're in the military and overseas. But 10 or 12 of them dealt with Mike and other men. And so the person who opened up his computer, turned him in, and discharged proceedings against Mike were initiated. Mike was asked point blank, "Are you gay?" and refused to answer. And the military commenced discharge proceedings against him that lasted about 16 months. During that period of time, Mike received letters from every single member of his unit, all 24 people he supervised, all saying that discharging Mike from the Air Force would be a horrible thing because he was so badly needed in their unit and was a hero. While his discharge proceedings were pending, his commanding officer recommended that he be promoted from major to lieutenant colonel. And unfortunately, on the day that his hearing was set to start, he was advised that the evidence against him in the emails would likely result in his discharge. Now, he hadn't engaged, and there was no evidence that he had actually engaged in any homosexual conduct, but the definition of homosexual conduct in the law and regulations included many things, but it also included the propensity to engage in homosexual conduct. So homosexual conduct was defined as the propensity to engage in it, and these emails were evidence of that. And Mike was going to have great difficulty rebutting the presumption created by those emails. So he was told that if he challenged his discharge and lost, he would get a dishonorable discharge and lose all the benefits he had accrued over 20 years of military service. So he accepted an honorable discharge and left. He then started speaking out publicly about Don't Ask, Don't Tell, along with a lot of other people. He mentioned that he was on Rachel Maddow several times. He also testified in front of the United States Senate about Don't Ask, Don't Tell before he testified in our trial about his experience. And because he became such a well-recognized, articulate spokesman about the impact Don't Ask, Don't Tell has on individuals and military preparedness, he actually was invited to join Lady Gaga at the Video Music Awards in Los Angeles a few months after our trial. And so he was in her hotel room when she put on the meat dress, if you remember that. Walked her down the red carpet together, and actually she walked him on stage when she received awards that night. So that's a little bit about Mike Walmy, the first person you saw in the video there. Before I take questions, I do also want to tell people about what happened since the events described in the video. You saw in the video the president signing the bill that repealed Don't Ask, Don't Tell last December. It was interesting and fun to be there and watch him sign it. But the bill that was signed did not repeal Don't Ask, Don't Tell immediately. It had to await a certification by the President, the Chairman of the Joint Chiefs of Staff, and the Secretary of Defense that the military was ready for Don't Ask, Don't Tell to be repealed. In the meantime, the government appealed the judgment we had won. As you saw, the district court issued an injunction against the government, enjoining it from enforcing or applying Don't Ask, Don't Tell. After an appeal, the government got from the Ninth Circuit a stay of that injunction. We then briefed the merits of the constitutionality of Don't Ask, Don't Tell, and based on some of the things that we saw in the merits briefs, in May of this year, we filed a motion with the Ninth Circuit to vacate the stay. And we thought it was important to do that because the military was still, this year, investigating and discharging people under Don't Ask, Don't Tell, even after the President signed that bill. And so on July 6th of this year, the Ninth Circuit granted our motion and put back in place the district court stay. And the government fought very hard about that with emergency motions and so forth, but the stay of the injunction, the stay was lifted and the injunction was put back in place in July. Once that happened, suddenly, the President, Secretary of Defense, and Chairman of Joint Chiefs of Staff suddenly made the certification they had to make the repeal effective. And the repeal of Don't Ask, Don't Tell by Congress became effective last week on September 20th. In the meantime, on September 1st, we actually had a oral argument in the Ninth Circuit on Don't Ask, Don't Tell. And at that argument, we argued the merits, we argued standing, and we argued about the impact that the repeal bill had on the case. And so, literally an hour and a half ago, I got the decision from the Ninth Circuit, which now finds that the case is moot because of the repeal, and vacates the district court's judgment, and vacates every single ruling the district court made. So that anybody who now wants to challenge his or her discharge under Don't Ask, Don't Tell has to start from scratch and has to prove again that Don't Ask, Don't Tell was unconstitutional. We're not quite done with this. I think we're going to see a rehearing before the full Ninth Circuit, but this is an important ruling because we were trying to maintain our case as a precedent for people who are challenging their discharges under the unconstitutional statute. We have people who are suing for back pay or reinstatement and things of that sort, including Mike Alming, who's suing to be reinstated. Another interesting thing that has happened is that when people were discharged under Don't Ask, Don't Tell, even if they got honorable discharges, they received half of the severance payment that they would have received if they were just normally discharged. And then there were actually 900 to 1,000 people who were discharged with less than honorable discharges under Don't Ask, Don't Tell, who therefore are not eligible for VA benefits, GI Bill, medical insurance, burials, and all of that stuff. So this Ninth Circuit ruling that we got this morning is, I shall say, disappointing, but we're going to continue to fight on it. Anyway, questions before I tell you more stories? Yeah.
Where are you with your equal protection charge?
We included an equal protection claim in our complaint. The district court dismissed it based on some prior Ninth Circuit cases that were called Witt against the Department of Air Force and Phillips against Parrott. So we